apologize for that delay. That was supposed to already be live streaming on YouTube, and I'll get back to that in a minute, how you can get back to that. I want to welcome everyone to the oral argument session of the 10th Court of Appeals meeting on the Glen campus in Waco, Texas. MCC. I apologize. I've done this so many times at Glen and Sam Houston State, and so I forgot. Thank you, Matt. It's one of those things that we've not done before. It's our first time on the Glen campus, and it was a very fortunate Glen. That's it. Did it again. MCC campus, and it came about as a very fortuitous meeting between Justice Smith and Dr. McCown, the president of the university, and so she expressed interest in having us here, and so that's why we're here. Because your leader chose to meet with us and to see if we could make this happen. And it really was we met, we talked, we were trying to pick a date in between with our other events that we do and regular oral arguments when we needed to have oral argument. And it was realized that yesterday was Constitution Day, and Dr. McCown immediately seized upon that would be a great way to introduce this type program to MCC. And so she sort of liked that idea, the idea of making it an annual type event connected to Constitution Day. And so I can see by the number of people that are here that she pushed it on campus and she made it happen. So at this time, I'd like to recognize Dr. McCown and turn the mic over to her for anything she would like to say.
I want to thank the judges for being here. This is amazing for us. Students, would you give them a hand for being here? And thank you, attorneys, for being here. And I want to thank the professors for encouraging all of you to be here. The departments that I know we have are paralegal, criminal justice, government, law enforcement, history, and real estate. Thank all of you for being here today.
Thank you. There were some folks that made today happen from the university or from the school. Laura Rowell, who's in the back, I came in Friday to check the setup. It was the first time I had walked into a off-site argument where everything was set up, ready to go. I didn't have to move a chair or a table or anything. She had it set up perfectly. And so for that, I think you are to recognize Laura with applause as well. This is not to sell short Lindsay Bennick, who is the assistant to the president, Edgar in IT, who's wearing the ball cap at the back. He's going to make sure that y'all can hear us all day. We do have, unfortunately, but at the same time, we're grateful for the presence of law enforcement, the police chief here on campus, Clayton Williams, and Hondo Armijo, who are providing security today. We get to come to the campus as opposed to have the oral arguments in the courthouse because of a statute that says we can meet anywhere within the county seat of the 18 counties in our district, which that is a relatively new statute. Previously, we could only meet in the county seat of the court where the court was located in McLennan County. We get to travel all over now, all over the district, and we've done that. But you know, coming to another campus within Waco is really great. We've been to Baylor, and now y'all are the benefactor of that statutory provision. I want to introduce our court staff. Most of the folks on this far left-hand corner over here are staff attorneys. They are career attorneys that work for the Court of Appeals. If you have questions that you want to direct to them instead of to the judges, feel free to do so. would like for you to turn off all your electronics, your phone, put them on silent. One thing that I need to cover that we do differently in this environment than when we're meeting at the court is that if you want to take a photograph up until the point that the attorneys come to the lectern, that will be allowed. It is not something that we allow in the courtroom, but in this environment we do. The other thing that is very different than when we have this session in the courtroom is that the first 3 minutes of each attorney's arguments, they will turn to you all and place their legal arguments that they're going to make to us in context for you. That 3 minutes is entirely up to them, how they want to spend it, but the effort is to place for you all their arguments that they're going to be making to us. To follow the case, if you're expecting to hear a stirring cross-examination of a witness today, you are going to be disappointed. These cases have already been tried. There are already judgments in place, and their lawyers are trying to overturn those judgments. And so this is a intermediate appellate argument. It's the same basic procedure that you would see at the United States Supreme Court, the Texas Supreme Court, the Texas Court of Criminal Appeals. There are 14 courts across the state that do what we do. Our court is composed of 3 judges. You're looking at them. Some of the courts have as many as 14 judges, and they sit in panels of 3, but they all do the same thing that you will see today. All appellate courts are organized basically the same way. There's a chief justice, or in these other courts where they're sitting in panels, there's a presiding judge that sort of regulates the proceeding, and then the other 2 panel members, and they sit by seniority, meaning that to my right is Matt Johnson. He is the most senior associate judge or other justice on the court. And then to my left is Steve Smith. He is the junior justice, although I'm not supposed to say it. He's also the oldest judge, but we're not going to talk about that. But and on a court that's made up of 9 people or more than 3, you can continue that process so that it is the next most senior would be to the right of Matt. The next would be to the left of Steve, and it goes back and forth that way so that the most junior justice would be the furthest one on the left. So you know that when you're looking at the Supreme Court panel in an argument, Texas Supreme Court, United States Court of Appeals, or United States Supreme Court, the one furthest to the left of the person that's in the middle will be the most junior justice on the court. We're going to argue two cases today. Well, first of all, it is Constitution Day. I've just introduced the judges. Matt, you got anything to say?
Well, I again want to echo the sentiments of thanking MCC for hosting this event. It's actually a little bit of a homecoming for me because the first time I was in this building, I was a 15-year-old taking driver's education at the new Waco High School. And this was the new Waco High. The old Waco High was downtown. And of course, MCC acquired it. And I was also a student here at MCC for a summer session during my college career. But I'm so glad so many people have turned out. I hope you find this informative and you get to see a little bit of how courts that don't really get a lot of attention because it's pretty dry subject matter for most people, at least see how we operate.
Steve, anything?
Appreciate the opportunity to be here, President. Appreciate the opportunity to have met her. Just as a chance meeting, and we got to talking about the ability of us coming out here, and I'm glad it's worked out. We're looking forward to being with you today.
And if you'll look at your pamphlets, there on the page that faces the first seal, you'll see a court's website, and you can go to that website and you can follow the cases that you hear today or any other case in the Texas judicial system. You can sign up for what's called case mail on those cases, and they will send you an email anytime that something happens in the case. So when the opinion in this case is eventually issued, you will get an email that tells you that something has happened, and you can go to the case file on the web and pull up a copy of the order or the opinion or whatever has happened. You'll be able to follow. If by chance you want to review the oral arguments today, we are live streaming this on YouTube. Our YouTube channel is listed on that same page. Some of the courts delete the live feed that is presented there immediately after oral argument is over. During the pandemic, this was the only way to make our court proceedings open to the public. And we liked it so much because people commented on it and said, we can go, and watch this at any time we want to. And so we made the decision, the three of us, that we were going to leave our oral arguments up on YouTube, on that channel. And so at a future date, if you want to, you can go back and revisit the events of today. And with that, we've got two cases on our 10 o'clock docket. Is the first one is Orler versus State. I would like announcements from council.
Morning. My name is John Kuchera. I represent the appellant. If you're like me, before I went to law school, I didn't know what an appellant was. So I mean, if you already know, great. If you don't, I'll give you a little tutorial.
John, I'm going to stop you for just a minute. Your 3 minutes are going to start in just a minute.
Oh, haven't started yet?
Yeah, I'm just looking to see if you're ready to go, and I see you are. Sterling, are you ready to go?
The state is present and ready. Sterling Harmon with the McLennan County Criminal District Attorney's Office appearing for the state.
Thank you, counsel. Hang in there, John. I'm going to take the announcements on the second case, which is Castlow versus State.
All right, pleading homicide, represent the Gulf Yard.
Thanks, Sarah, for Leon County. We're ready.
Thank you, counsel. Now, John, your 3 minutes begin. Please proceed.
Hopefully I won't take 3 minutes. I represent Mr. Orler. Mr. Orler is the defendant. He's now the appellant. He's one of the defendants. What that means is he was charged and convicted of a crime. He is now incarcerated and he's appealing his conviction. The facts of this case are a little embarrassing, but basically this is it. He's charged and convicted with indecency with a child by exposure. Now, the facts basically are that he lived in a small house with his girlfriend. Occasionally, they would engage in sexual intercourse at night. His daughter, I'll refer to her as TT, lives in the house with them occasionally. Several times she walked out in the middle of the night and witnessed them in the middle of having sexual intercourse. At some point, Mr. Orler became aware that she was watching. He did not prohibit her from watching. He didn't tell her to leave, and they didn't stop and told her if she wanted to watch, she could. And so this happened, I don't know how many times, somewhere between 8 and 20, depending on the facts in the record. So my argument today is simply that the indecency with a child by exposure statute was never meant to cover this kind of conduct. So hopefully you'll get a little sense of that when I make my argument, which I'm going to do right. Okay.
Counsel, you may proceed when ready.
Okay. May it please the court, Harmon. In my initial brief, I stated that I thought oral argument was helpful in this case because I don't think the statute, again, as I just said, was ever intended to apply to the conduct here. So with a view towards trying to find out if there were any Texas cases that were similar, I did a Lexis search using the phrase indecency with a child and 6 words of exposure. Came up with 814 Texas cases, published and unpublished. I looked at every one of them. Also reviewed 36 cases addressing Article 535C of the old Vernon's Penal Code, and that statute was labeled indecent exposure to a child. Basically, the statute provided it shall be unlawful for any person with lascivious intent to knowingly and intentionally expose his or her private parts or genital organs to any other person, male or female, under the age of 16. And here's what I've done. 292 of these cases involve situations where the defendant was charged and convicted not only of indecency by exposure, but also with indecency by contact or sexual assault. Well, again, one of my arguments is that the conduct has to be directed toward the child. Well, if there's indecency by contact involved or sexual assault involved, obviously the conduct is directed to the child. So I didn't look any further into the facts of those cases. I found 107 standalone indecency by exposure cases involving situations where the defendant exposed himself, in one case herself. And of those 107 cases, 104 of them involve this basic scenario. The defendant would direct his attention toward a child or a group of children and expose himself, typically masturbating or in the process of masturbating. So stated another way, these were all cases, these 104 were all cases where the defendant's activity was specifically directed at the child or a group of children. Now I found 3 cases out of that 107 that had some similarities to this case. I'm going to go through those and then I'm going to give you my opinion on why they are distinguishable. First one, this is an unpublished case styled Grant versus State out of Corpus Christi. I'll give you the appeal number. It's 13-10-00421-CR. The defendant in this case is a 32-year-old man. He is playing cards with his friends. He has his daughter who's 14 years old playing there. Also a friend of hers who's 14 years old. Not a great dad, apparently. They're all drinking and the girls become drunk and go to bed. Dad gets up after a while and gets into bed and begins to have sexual intercourse with the 14-year-old non-daughter. Daughter wakes up and screams and dad quits. Well, dad gets convicted of sexual assault of the 14-year-old friend, and he also gets convicted of indecency of the child by exposure as to his own daughter. And his argument on appeal was that, well, there's no way she could have seen my genitals. There's just no way. And of course, as I pointed out in my brief, the child doesn't ever have to see the genitals. It's what the defendant exposes, not what the child sees. And most cases obviously involve the child seeing it because that's how the case gets reported, but that doesn't have to happen. The Court of Appeals simply said the evidence was clear that Grant exposed his genitals knowing that his daughter was mere inches away. The point is, when he exposed his genitals, his daughter was right there, okay? They said it's a jury question to determine whether he did this with an intent to satisfy his sexual desire. This statement appears in my brief, but I think it's important. Indecency with a child by exposure is not a victim-centered offense analogous to aggravated rape or indecency with a child by contact. Because indecency with a child by exposure centers on the mental state and actions of the perpetrator, not the harm done to the victim. That's Gaines of each state, 149 Southwest 3rd and 708. I'll make this statement. When Mr. Orler and his girlfriend got into bed to have sex, obviously Mr. Orler intended to arouse or gratify his own sexual desire and the sexual desire of his girlfriend. There's absolutely no evidence that the presence of this daughter later on, whether it was there or not, had any effect on that whatsoever. Again, and I'll get to this at the very end, it has to be done in the presence of the child and it has to be directed at the child. All right, second case. This is also an unpublished case, McKinney v. State, inside of Eastland, 11-15-00228 CR. The children were living with mother and her live-in boyfriend, who's the appellant, the defendant, and they walked in on them. and they were having sexual intercourse. And they tried to leave, and the appellant tied them both up in a chair, forced them to watch. Okay. Now, two things, and that's the closest one fact-wise to our situation here. The two distinguishing factors are, I think it could be inferred that if they tied them up and made them watch, it's possible that you could infer that the appellant, the fact that they were tied up and made to watch had an effect on his sexual arousal. But the most important thing was he never argued on appeal that the evidence was insufficient. Okay, his only argument had to do with, and this shouldn't surprise anybody, he had enhancement paragraphs. His only argument on appeal was the enhancement paragraphs weren't sufficiently proved. So the Court of Appeals didn't address a sufficiency issue in this case. Okay, the third case, and this is the 1968 case, and this is from the old Article 535C. It's Keel v. State, 434 Southwest 2nd, 687. Let's see here. The appellant had a 16-year-old at his house, and he had a girl that was an employee come over, and he would take off his clothes, and he would engage in sexual activity with the adult, but the child was present. Okay, and that conviction was sustained. Says the evidence also deduced that when the girl went to the apartment to have sex with the appellant, the testimony was elicited by the defense that while they were there were lewd pictures shown. And again, that's somewhat similar to some of what we have here. But again, this is the old statute. The defendant never argued that the evidence was insufficient, so that issue was not before the court. His only argument was that the court erred in feeling that he had a whole bunch of pretrial motions that were all denied, and that was his arguments were all about that. So these are the only three cases that I found, and I'll go out on a limb here and say that I looked at everything I thought that there was out there to see that are even close, and for the reasons I've just given, I believe they're distinguishable.
Counsel, your brief focuses a lot on the timing of the exposure.
Correct.
And that she may not have been, or the record does not show that she was present when he disrobed. I believe it's the term that you use in the brief. Are you suggesting that if the person walks in on the minor, on the child, already disrobed, that is not an exhibition?
Well, the short answer is yes. I mean, I think the case I cited where they tied the kids up and made them watch would be distinguishable because that's a separate act that could evidence an intent to be aroused by the children's presence. But I quoted this and I was going to finish with it. And this was taken from the practice commentary that I cited in the initial brief. And this is from Sawyer v. State, 655 Southwest 2nd, 226. Knowledge of the child's presence is included as an element of the indecency portion of section 21.11A2. For everybody here, that's the indecency by exposure statute, because with children, there is always danger they will appear unannounced. And in this situation, an unwitting exposure should not be criminal. So based on the record, with the exception of the hotel room incident, which I'm going to get to here in a second, that's what always happened. They had no advanced knowledge other than the fact that on some occasions they thought, well, she's been here before. She was unannounced for the incidents that took place at Mr. Orler's house and the girlfriend's house. She came into view of an event that was already in progress every time.
Counsel, would it be able for a jury to infer the intent with the invitation to come back and watch again anytime you want to?
Okay, that's a fair question. There's a difference, in my opinion, between inference and speculation. I would argue that that would be speculation, but obviously that's your call, man. It's a fair question.
What about the state has referred to, the child having videotaped and I don't remember exactly from the briefing, and as you know, we haven't been through the record in detail at this point. We will before the opinion's written, but the whether or not that was done at her suggestion or his, but nevertheless, he was very aware that a video was being made that is somewhat comparable to other videos that he himself had made, as I understand it from the record.
And I addressed this in the reply brief. The state argued that, if I recall, basically that they commanded or directed or ordered the child to film. And in my reply brief, I go to some length to set out all the passages. That's not what happened. She was allowed to watch, and the one occasion she clicked on the iPad and she was instructed, I can't remember by a girlfriend or dad, if you're gonna film it, film it, just using this. Okay. So again, those are and also there was evidence in the record of meth use. Okay, so those are bad things. I'm not here to suggest that this is a great setup for a boy to raise a daughter. What I'm saying is that is extraneous. It doesn't have anything to do with the elements of defense. That would be my argument. We also have the incident in the hotel room where Mr. Orler and his girlfriend were had sex, and TT was in the same hotel room. I saw a replica the other day of the cabin that Abraham Lincoln grew up in, and it was tiny. It was like, just based on looking at the picture, I worked construction for 15 years. I'm pretty good to guess, and it looked like it's about 15 by 15. And we've all seen pictures of these pioneer cabins with a tiny dwelling or maybe just something built into the side of the hill. And this mom and dad and kids, some of them little, standing outside to have their picture made. Well, we got to assume, I think, that occasionally in those little dwellings, mom and dad had sexual intercourse. We can also infer that at times the kids were aware of what was going on. I'm not suggesting that that's an ideal setup. It's not criminal. Unless there are any questions, I yield back the rest of my time.
I do want to explore the question of the second issue, which is, to put it delicately, is the difference between the anus and the butt, and the testimony as to whether or not that is sufficient when the child referred to using, shall we say, the vernacular of children, that she had seen her dad's butt during these. Would you address the sufficiency?
Well, I addressed it to some extent as best I could in my principal brief. The general rule is that terms that are not statutorily defined can be given the normal use in regular parlance. But based again on the practice commentary says, no, for anus, we have a specific definition. And that specific definition, and I didn't memorize it, it's in my brief. The evidence in this case doesn't even come close to satisfying that. But BUTT doesn't cover it. Now, the cases cited by the state in its brief all involve situations where the defendant penetrated the anus with his sexual organ. Well, that's pretty easy. But there's no evidence, first of all, that he ever exposed his I can't remember the definition. He certainly didn't do what the term requires, and there's no evidence that he ever did that with the intent to excite anybody sexually. So that would be my short answer to that question.
Anything else? Anything else? Okay, thank you, counsel. You'll have 5 minutes for a vote. Counsel, this time you have your 3 minutes to address the audience.
Thank you, Your Honor. Which is the best way to do this. I want everybody to be able to hear me. First off, I want to thank the MCC faculty and students for having us here for this opportunity. And thank you on behalf of myself and my boss, Mr. Josh Keaton, who is our district attorney. The case, as you've already heard from defense counsel, involves 10 counts of indecency with the child by exposure. You might be able to glean from that this is not a case of a random drive-by pervert outside the schoolyard out of exposure. This was the defendant's 11-year-old daughter. And the 10 counts were to address multiple occasions of intentional exposure, having sex with a co-defendant, the father's girlfriend, at least 20 times as the girl testified. So I ask you to keep in mind that there's not a moral equivalency between the random flasher and what happened here. This is a case, the moral dimensions of which are in essentially a continuous sexual abuse of this little girl. Some of the topics that are going to be talked about and have been talked about, they might suggest to you maybe a sense of levity about some of the things that are going to be talked about, maybe some, double entendres, that sort of thing. But keep in mind the dimensions of this case. This is not a laughing matter. You have an appellant here who is fighting for his liberty and essentially his life. And you're also talking about a little girl who at the age of 11 was subjected to sexual abuse that, save for grace, will affect her the rest of her life. So as you listen to the argument, I would ask you to keep that in mind. And again, thank you for having us here.
You may proceed when ready.
May it please the court, counsel. The issues presented on this appeal essentially are 3 points regarding sufficiency of evidence and 1 regarding the issue of the rule of lenity. In point of error 1, there are 2 subpoints, the first of which is whether the evidence was sufficient to prove appellant's guilt because the child was either not present or awake when the appellant initially exposed himself. The second point of which is whether or not the evidence was sufficient to prove appellant's guilt because the exposure was not directed toward the child. The state's position is that nothing more is needed for this court to determine these issues other than reliance on the well familiar Jackson v. Virginia sufficiency standard. That is, first, application of facts to a hypothetically correct jury charge, crediting the jury's reasonable resolution of conflicting evidence, and crediting the jury's reasonable inferences based on the evidence. The elements which were needed to be proven on all of these counts were with the intent to arouse or gratify sexual desire. The defendant exposed his genitals or anus knowing that the child was present. The first point of error, or the first subpart of the first point of error, relies on the appellate's proposition that a child victim must be present at the point when the defendant first exposes himself. Otherwise, he gets a King's X. I didn't catch this on the initial briefing, and so reading my brief, that hopefully this is explanatory to the court. As I say, I didn't catch that on the initial briefing. Rereading it and preparing for the argument, it occurred to me, this is what the appellant is claiming, that if a defendant has bared themselves, exposed themselves, that the statute does not recognize any criminal act if that the child is not there at the moment when the defendant disrupts. That can't be what the legislature intended in writing the statute, and frankly, it's offensive. You have a defendant here who says, you know, I was having sex with my girlfriend when my 11-year-old just by happenstance walks in the room. And it's ollie oxen free at this point, because she wasn't in here when I dropped my trousers. So now that I have already exposed, I can continue that exposure. And while I'm exposed, I can have sex with my girlfriend countless times. I can describe what I'm doing. Specifically, what this little girl testified to is that Daddy explained all what was going on. He said, this is the missionary position. And then they flipped around and then they did it doggy style. And then after that, well, we're going to do some oral stuff, and this is called 69, sweetie. This is an 11-year-old girl that he's doing all these things in front of. And then he says, well, did I direct or did I allow the video? Well, it doesn't matter, because since she wasn't there when I just wrote, this exposure doesn't count against me. This is not criminal. I can let her go ahead and video all this stuff. Oh, and then at the end, hey, you want to see my penis tattoo of the Hello Kitty? That's all that he did. The jury heard this, and you're going to say, ollie oxen free, no criminal liability, because the statute says at the point of exposure, and the little girl was not there at the point that he exposed himself. That's a bizarre interpretation. If anything, the statute contemplates not an active exposure, but a state of exposure, a condition of exposure.
Counsel, what is the evidence that was available to the jury from which they could infer that he did the exposure for sexual gratification of another?
Oh, very simply, that the statute requires that with intent to arouse or gratify sexual desire of any person, the person exposes their genitals or anus. He was having sex with his girlfriend. He was obviously had exposed himself to gratify his and his girlfriend's sexual desires.
So you're saying that the exposure to his girlfriend is all the exposure that is required under the statute?
Well, that's the mental state, yes, that the exposure was done to arouse or gratify sexual desire. And obviously he was doing that because he was having sex with his girlfriend.
So,
in other words, the sexual gratification or desire does not have to be directed towards the child. It's the fact that he was exposed with the intent of arousing or gratifying.
you don't think the exposure has to be to the child for the gratification?
Yes, that would be a shorthand way of saying it. I don't want to get off in the weeds as to what constitutes exposure and what the child saw and didn't see, but yes, the child needs to be present. And there needs to be an exposure, and there needs to be an intent to arouse and gratify. But if those three things are present, they're not codependent on each other, in other words.
Okay. You don't think the exposure has to be made to the child?
The child
Or-
needs to be present. Yes, sir.
When he's exposed, but the sexual gratification, you don't think has to be as a result of the exposure with the child present?
No, and such a construction would essentially get the whole purpose of this, of trying to protect children from being, pardon the phrase, exposed to this sort of activity.
So you are saying, if I understand your analysis of the statute, that anytime that a child walks in upon adults, their parents included, that are in disrobe, presumably having sex, then they are in violation of this statute.
I would say if you don't take the proper remedy that most sane parents would take of, cover it up. What do you need, sweetie? I'll get you a drink of, you need to step outside. You need to stop what you're doing. You don't need to continue on with your doggy style and your 69 and go ahead and video.
That's one question I have. What significance do you attach to the fact that they continue in their behavior once the child is in?
And again, counsel referred to some case law that talks about, we want to make sure that this does not happen. Kids are curious. They wander into places. It's what you do at that point. The child's present. Yep. Do you stop? Do you continue? Obviously, you don't want to be exposing the child to this sort of behavior. So yeah, you need to stop. You need to cover up. You need to, shoo the child out in the hallway, close the door. You need to interrupt yourself. The fact that, okay, and that is a required element that the actor knew the child was present. Once you know the child's present, you don't get to keep going, in other words.
So if the child's peeping through the door, the keyhole, not a problem.
Well, if you don't know the child's present, certainly you can't form the requisite mens rea to commit the offense, obviously.
But the mens rea is that the child, the child is present and you're exposed for sexual gratification.
Yeah.
What you're not giving a causal link to the gratification has to be a result of the child being subject to the exposure.
Correct. And moving on, well, I would at this point mention that many of the points and arguments that the appellant has made, they rely on what I would consider out of context phrases from various case law. For example, in Ex parte Chapin, that case dealt with a double jeopardy or collateral estoppel claim. In Velasquez v. State, that dealt with the question of whether exposure must occur in a public place. But the appellant uses those as authority on it, but the issues that were decided that had nothing to do with when exposure had to take place, and those were decided as authority on that first point.
Council, I'd like for you to move to the issue of the anus versus the butt testimony,
Sir,
the second issue.
and I'll start with another point of case law that's cited by the appellant in law enforcement employees v. Carey, which is a 40-year-old federal civil case that dealt with prison guards being required to submit to body cavity searches and the description of how the anus is exposed in regard to conducting body cavity searches. And then going back to what's already been discussed, the fact that neither anus nor exposed is defined in the statute. Anytime that someone disrobes and uncovers the lower back half of their body, you have a condition where it, depending on the facts adduced at trial and made known to the fact finder, where you have a condition of showing that there was an exposure of the anus. It is not common in these sorts of cases to allege a count, because the statute does say exposure of the genitals or anus with intent to arouse or gratify the sexual desire of any person. And it's a natural assumption that you would allege the genitals, but the statute does also include the anus. I would refer the court to the case at bar as to what this child observed. She mentioned, I saw my dad's butt. I also saw my dad's D-I-C-K. The appellant argues that in some of the case law that I've cited in my brief, that the complaining witness, the child, is given some credit, that there was always something more than just the use of the term butt or bottom. Well, I'll suggest that there's a lot more than just her description or use of the term my dad's butt. And I've gone pretty comprehensively as to what she was observing, all kinds of sorts of sexual positions, a description by dad of what they were doing, her observation of orgasm and ejaculation by dad and his girlfriend. It's a reasonable inference that the jury could find, a rational jury could find, yes, he did expose his anus under these proper conditions. Granted, there's a lot to be said about prosecutorial discretion. A lot needs to be said about an analysis of what the facts actually show, what was adduced at trial in determining this. I'm not saying that this would be a common occurrence. This might be an unusual case. I don't think it's a unicorn. It might be a zebra. But the statute says what the statute said, the exposure of the anus. And again, what I believe strengthens the state's argument here is the fact that the child does not actually have to see the exposure. Counsel mentioned the penetration cases. Well, you don't have to prove penetration here. You don't have to prove that the child saw anything. All you have to for the jury to find is that yes, there was an exposure of the anus. And I believe that the facts that TT testified to certainly support a rational jury finding that yes, he did, at least on those 5 occasions they found him guilty, that he had exposed his anus under the proper circumstances.
One of the issues that counsel didn't open on, but I need to ask you about is the fine and accumulation order. Can you address the appropriateness of how the accumulation should be done when the offenses are stacked, or as in this instance, 9 of them will run consecutive.
And I frankly did not prepare that for the argument. I'll shoot from the hip and say that when you have accumulation of fines, first off the concurrent, and I believe I'm in agreement with both the council on this, that if you have concurrent sentences with concurrent fines, that you don't stack those. That you would stack the fine that was assessed on the stacked offense.
Okay, so you can stack fines on offenses that are not stacked. Excuse me, that on offenses that are run consecutive, the fine that is related to that offense, you can have consecutive fines, if you will.
Yes, and that's my wet finger in the air response on that.
Okay.
I'll take a look, see, and
Were these all tried in the same cause number?
yes.
So it's one cause.
Yes, but the nature of the offense, allowing for the accumulation.
Your accumulation, what's the nature of the charge?
Yes,
That's
it's
fine.
one trial.
But because it's in one cause, does that affect the stacking of the fines?
Well, that's a great question. I'll look it up.
Good, thank
Anything?
Thank you.
It's not an effort to stuff the panel, but we may have stumped the council at this point.
Difficult to do, Your Honor.
And you cite, come on up, you got your 5 minutes for both. Remember, that you've got, you've cited some cases that were not in your brief. And so the 3 cases, were they, and we'll need this formal citations to those, by Friday. When can you get us a supplemental brief on the fine issue? Can you do it by Friday as well?
I think I can, sure.
Okay. You have 5 minutes. You may proceed when ready, council.
Thank you. Thank you. If I understood right, you asked, Mr. Harmon, if there's a child present and the defendant knows the child's present, doesn't matter when he exposes his genitals, he's guilty. And I made this comment in page 3 of my initial brief. If that's true, then the state has rewritten the statute. The statute, according to the state, reads this way: if at any time a child sees a person with his genitals exposed, the person has committed an offense. It's not what it said. It's not what it said. Page 28 of my principal brief. That's a big deal, so I need to find this. Excuse me, page 24. Where I'm going with this is, Justice Burr asked a question about whether the butt was sufficient, using the word butt is sufficient. And page 23, the comment I made was, and this is from the practice commentary, this is the fact that anus is not statutorily defined doesn't mean that it doesn't have a legal definition. It does. I take this again from the practice commentary. Anus is a new term and is intended in its strict anatomical sense. The posterior opening of the alimentary canal, thus excluding the buttocks. So that's pretty definitive. If that's the law, then there's certainly no evidence of that. That's what I would argue.
What about the cases where there's a long line of cases where the law has been that children of tender years don't have to use the same level of terminology and words that adults would use for that offense.
Well, those all, based on my reading of cases, that language is always used in the context of penetration or contact. You know, it's oftentimes because it's against the law to contact the child's genitals with your sexual organ or whatever. It's also against the law to penetrate. So what's the line between contact and penetrate? The cases that I've seen that deal with what you're talking about are talking about the child doesn't have to know, doesn't have to specifically describe the anatomical anatomy of the front of a woman to get a conviction. But, well, I don't see that applying here at all, because we have essentially a statutory definition, even though it's technically not statutory. It's difficult for me to imagine in this context where there's no anal intercourse involved, why anybody would expose their anus to arouse sexual anybody's sexual desire. That's just an unsolicited opinion that means nothing. But anyway, see, look at my time just about out here. Mr. Harmon suggested that Mr. Orler was the one who told the child, this is missionary style, this is doggy style, this is 69. There is no evidence of that. This child was curious. This child had already looked at adult pornography on her own. And you can look at volume 5, page 103, volume 5, page 97, and you can look for yourself and see if that was anything, any information that was ever communicated to that child by the defendant. I don't think it was. And by the way, she was 13 when she testified, not 11. She was curious. I'm not here to argue with the fact that what she saw and the number of times she saw it will never have any sort of long-lasting psychological effect on her. I mean, I can't argue that, but you know, one of the things that the state was looking at doing was taking the child from the home. That's a big difference between sending a guy to the penitentiary for 10 years. So again, this is certainly not anything I would hold up as an ideal father-daughter relationship, but I just don't see it violating the statute. There are no further questions. I yield back the rest of my time.
Thank you, Counsel.
Thank you.
This case is submitted and y'all are excused. Thank you. I know that some of the audience may need to shift for classes. You're free to come and go at any time that you need to. And we'll give just a little bit of break here for the attorneys to take the table and start the second case as soon as things have kind of calmed down. There will be a question and answer session after this case.
Back.
Yeah.
At this time, the court calls Castlow versus State. If y'all take your seats, close the doors, counsel, you can approach the IT department. Edgar has now set you up a microphone, so it'll be a bit easier for you.
Good morning, my name is Clay Thomas. I'm the Philip lawyer for John Winston Castlow. Mr. Castlow is convicted of aggravated assault, sexual assault of a child, and sentenced to life in prison. Now, you know, it's an interesting thing. You probably don't know this, but a lot of times, clients that when I'm a trial lawyer, they'll come to me and they say, well, your job is to get me off, get me free. I said, well, no, that's not really true. My job is to make sure that you get a fair trial. And I'm here to say, at least in this case, we believe that Mr. Castlow did not. At some point, Mr. Castlow and his wife decided to engage in a business transaction on the internet. And some of those had to do with her selling nude photos of herself, things of that nature. And it appears that at some point, Mr. Castlow got the smart idea to write a story about how he sexually abused his daughter. And that's at some point, to all the witnesses, wife didn't know it. She receives an anonymous email from someone overseas who says, hey, this is what your husband has been saying. He comes to the police department and he says, you know what? My wife is trying to blackmail me in order to get possession of the child. Okay. So at some point he's asked if he take a polygraph. He says yes. They arrange it. And for well over 3 hours he's answering this polygraph. And at some point he admits that he committed the act. What this case is about really is more about procedure and how we got to a point where this kind of evidence actually can come in. And that's what largely our whole case is about. It's not about the act, it's about how the evidence got there, whether that was appropriate. Hey, police court, counsel. It's actually a matter of the Texas courts that found polygraphs are unreliable. The legislature, the body politic, the group that forms our laws, has agreed with this because they have repealed Chapter 1703 of the Occupations Code. They did that back in 2021. Now, the point of that was that after listening to a report by Sunset Commission, it had decided that there were so many abuses which occur in the process of doing polygraphs that it could not help but do away with the commission. Part of that, of course, is because the commission itself was housed in the Texas Department of Corrections facility.
Counsel, was it repealed before or after the events of taking this polygraph? And does that matter in connection with the development and the suppression hearing in this case?
I would say that it was not appealed before, but I don't think that matters. Because Texas courts have already found that polygraph evidence is suspect, to say the least, is not allowed. But what that act did do was it pointed out exactly some of the problems in this case. It talked about the fact that polygraphers, you know, largely they're taught by the DPS. The DPS runs well over 70% of those guys. And it's set up so that DPS largely has a stranglehold on the process. Well, what is a polygraph supposed to do? A polygraph is supposed to elicit deception and nothing else. Deception. And do I think they're telling me the truth? And in order to get that done, you have to be unbiased. In Europe, you got an unbiased polygraph. Let's say, for instance, is your name Clayton Thomas? Well, yes, it is. So I've got my affirmative level here. Okay. And then obviously you would ask me something that is blatantly untrue. Or you finally get to a level that would indicate by my body functions how we would have how you would get a deceptive piece. So as you're going through, the idea is to try to get people to answer. For instance, you ask Mr. Castlow, did you do this? No. Okay. If it's deceptive, it's deceptive. If there's no reaction, then that should tell you something also. But the point is that you're supposed to go, and it's supposed to be an unbiased issue, but that's not how it works. And what you find out in this particular case is that this polygraph, as we want to call it, was well over 3 hours long. I would submit to you that that's absurd, that any polygraph would be that long. This was an attempt by the state to create a situation where you could actually get an admission. This was not a fact-finding issue. Now, I don't know how many of you have heard of the READ method, but the READ method is something used by law enforcement normally, and it's roughly run by probably 750,000 law enforcement officers around the country. And the method is, it's 9 particular steps. The first one you start off with is just a general interview, which certainly could fit part of the polygraph. But as you go on, you increase it. You increase the questions that you ask, and you do these things. Now, in this case, Lieutenant Salazar, who was an employee of the Department of Public Safety, and who was a supervisor of this department, these polygraph experts, she took this polygraph, which should have been just a yes/no thing, and she turned it into an interrogation. Now, typically, what the READ approach is that first you have this little talk with the suspect, and then you leave him in the room for about 5 minutes. Kind of increases anxiety a little bit, and then you come back, and there are certain steps that you go through in order to get where you want to go, or where they say they want to go. What we have here is a bootstrap of that. If you take a look at the whole point and the READ, I believe the READ technique manual is about 656 pages long, and it covers any way you want to get something from anybody. But one of the big things is that anxiety. Okay? But I've got that already built into the polygraph. We have a polygraph examiner who says, I'm here to help you. I'm here to help you. And at some point, when she doesn't get responses that she thinks are truthful, she says, if you don't tell me the truth, I'm going to pack my shit and leave. How is that not an interrogation? You have put the fear of God in this man for the one purpose. He believes that you come here, you're going to help him. That's not what you do. And that's a problem. So that's the first piece. Okay, and so when we get down to the suppression hearing, what occurs there is the following. And you have to think about what an uneducated person, we're educated in the law. But what is the uneducated citizen think? Right? He's got to say that lost in my own words, I'm sorry. Things that it came out. Did you read his rights? No, I didn't trust it. Had to. He wasn't under arrest. He wasn't being held there. I love this line. I am not the investigator. So I'm not looking for because I'm not the investigator. Well, what are you? You're certainly not an unbiased party trying to run a test, are you?
Council, did the officer Salazar, did she say that she was not conducting an interrogation or that he was not in custody when they talked about the Miranda warnings?
She said he wasn't in custody. Okay. I don't think they ever made a big point on whether it was an interrogation or not, but it actually was fully through. And what was interesting was that at some point, toward the end, he says, I want to get up and walk out of here. No, I need to talk to the investigator first. Oh, I'm sorry. What does that tell me? That tells me you're being held. You've been seized. And the real question here is, what was their intent? Obviously, they were seized from the beginning. Now, I will tell you, I know this judge, and I like him a lot. But in this case, I think he's just flat wrong. This should have been correct.
What was the objection or the motion of the suppression, the basis of the motion of suppression?
I believe it was, they didn't want them to be able to use any of his admissions. Now, when we get to trial, it's a little different. I love this. When Lieutenant Salazar gets on the stand, prosecutor asked her, I understand you have a busy schedule planned for this week. Is that right? She said, yes, sir, I apologize. And why is that? Why do you have such a busy schedule? What is your job? Lieutenant Salazar says directly, I'm a lieutenant of the Texas Department of Public Safety. Been with the agency since 2001. And there are 17 agents that do polygraphs in the state of Texas. We assist other agencies, a lot of rural areas that don't have a lot of resources. We're a free resource for them. And I've actually traveled to El Paso to help with some polygraphs. So tomorrow, I'll be traveling to El Paso. And then he said, so what is your role with, or more in general, what is the role of DPS CID when it comes to rural jurisdictions and law enforcement? And Salazar said, so our role is to assist law enforcement local agencies with any possible in polygraphs. And this is before a jury. What I do in polygraphs. So our criminal investigation, we have a lot of different roles. We can help with narcotics, gang cases, and motor vehicle theft. We have all different divisions. In polygraph, all we do is polygraph.
But it's my understanding that none of the opinions were presented to the jury. Is that correct?
Well,
As the truth or honest, as the truthfulness or
well, as I think that once you broach that issue of this is my job, this is all I do. How can jury infer otherwise? How can a jury step and say, all we do is polygraph?
what do you mean infer or what?
Well,
Or otherwise about what?
well,
There
if,
are no opinions of whether the defendant was being truthful or untrue.
yes, it's how you got here that matters to me.
So your complaint is the process, that the defendant finally made admissions at the end of a rather long polygraph.
Well, as I said, I don't believe it was a polygraph. I think it was a beginning polygraph. This is what we're using. Now we have an interrogation.
I've seen that happen 100 times as a prosecutor and as a district judge. And the admissions in the end are routinely admitted into evidence. What's the case here that says this shouldn't have happened?
Case here that says it shouldn't have happened is a couple of things. One of them, and I think probably the most important, is that the prosecutor's already presents one as a polygraph. This is all I do. So what in the world is a jury to think, except for the fact that I was here for a reason to do a polygraph. Now, it's also interesting because at some point the defense counsel objects. Okay. And the judge says, well, fine, just as long as you clean it up. But that really didn't happen either. In fact, what we got was, well, we got this sanitized thought of, oh, your purpose here was just to help with the interrogation. Well, that's slightly disingenuous, don't you think?
Well, does law enforcement have to be honest when they're interrogating a suspect?
Law enforcement doesn't have to be honest, but they've got to be honest with the jury. And that's what we're talking about here, is how this affected the jury. Anytime, look, we all know that polygraphs are patently unreliable. And for my purposes, I would say they should be completely outlawed altogether. I think the legislature made that very clear. But what really matters here is that you're presenting to the jury a fact that isn't true. The fact that she was actually there for the purpose of helping him with an interrogation. And actually, she was. That was the whole thing here. This was an interrogation from the beginning. These kind of tactics cannot continue to stand.
But counsel, we're bound by the records here, and where is the objection of trial counsel that I think you would characterize as a shift between presenting her as a polygraph examiner versus presenting her as part of the investigation. Because we have to find trial court error, where is that objection that gives us that linchpin to address this issue in a direct appeal versus possibly in a habeas proceeding?
I agree. Okay.
Because I think following up on Matt's question, where it's not the polygraph examiner's opinion of the truthfulness of the defendant that is being introduced into evidence, but it is the actual statements of the defendant made to the polygraph examiner. It's a different question than whether or not we are going to introduce the results of the polygraph.
Okay. Let's see. Right after she says in a polygraph, all we do is polygraph, defense counsel objected to the identification of the polygraph. But by that time, the horse is already out of the barn. It's running down the pastures of jurors' miles. And that's certainly prejudicial, because most people don't know it's inherently unreliable. The jury would know that. And guess what? You can't even argue that issue because you just precluded it by saying, we're not going to talk about it.
Correct me if I'm wrong, but that was an objection to the person mentioning polygraph.
That's correct.
Where is the objection that says this whole process is flawed? This was a fake polygraph. It was an interrogation, and And these admissions shouldn't be allowed into evidence.
I don't know that there was one.
Feel free to go ahead and spend, wrap up.
All right. I think we all have to understand what we're looking at. When law enforcement, as a side group, law enforcement has the opportunity, if they like, to lie to people. Not a big surprise, but it's how we get there. We're looking for the truth. But there are other ways to get to the truth other than this way. This evidence could have been gotten other ways. It's not like this is the only way they could have got it. Nobody is smart enough to do it. I also think that there's a very big problem with switching back and coming back and saying, you know what? Yeah, her real job here was to do something else. Okay, well, even if that were the case, then the whole issue of the polygraph is false also. We gotta be truthful with the juries. Defense counsel has to be, prosecutors ought to also.
Thank you, counsel.
Thank you.
You'll have 5 minutes for rebuttal.
Thank you.
Counsel Edgar has set you up that mic, your 3 minutes, so you may begin.
Thank you. My name is Clint Sayer, and I appreciate the opportunity to come to your beautiful campus. I've never been here before. My background is actually started in law enforcement, did degrees in law enforcement and criminology from St. Houston before I went to law school, and then was commissioned as a consultant for a number of years. And I've been practicing, I used to practice at the Court of Appeals in Amarillo as a staff attorney, and I've been in the Bryan area for the last 15 years. And now I'm representing Leon County in this appeal. Probably the only background facts or background law that you need to know is that, as Judge Gray said, they are reviewing the trial court's actions. You're not hearing new evidence. They have to only consider whether the trial court erred in making the rulings that it made. So that's why it is critical that objections that want to be raised on the appeal were made at the trial court. And if those were not raised at that time, they can't be raised now, called preservation. And I think that's all the background that I have.
Counsel, you may proceed when ready.
Please support. As you've already had some questions about, there is an issue about preservation. Here, the only complaint that was preserved at trial was whether or not the defendant was subjected to custodial interrogation. And they litigated that issue. They said, well, this was 3 hours that he spent. And when you read the record, you're going to see the investigator, the examiner, say, when he expressed a desire to leave, she said, that's the door. She didn't say no. And rather than rely on either of us, you just look at the record and we believe that's what it's going to say. And it's also going to show that the trial court gets to make that evaluation of credibility. So the suppression issue was presented at a pretrial hearing. The defendant did not testify at trial, but he did testify at a pretrial hearing on suppression, and the court got to evaluate his credibility. We also have a comparison of the case that I cited in the brief, which was Doubthet, where there was 15 hours of interviews, and the Court of Criminal Appeals said no, that was not improper, where the person had been informed of their freedom to leave and that they were not in custody. Because the issue of custodial interrogation was the only one that was raised at trial, we believe it's the only one that you can consider now. And all of the complaints with regard to the polygraph were not raised at trial. The only complaint was after the polygraph examiner goes in and starts talking about, well, this is what I do, this is what I do for a living, this is how I help these local agencies. They approach the bench and say, well, Judge, we want to make sure that the jury doesn't hear about polygraph. And what does the judge do? Says, yep, I agree. We're going to not talk about that. We're going to use the term investigator. And the defense counsel says that's appropriate. That's what we need to do. That's invited. If it was error at all, that was invited. It was not anything misleading in the sense of the state presenting her as something different without the defense counsel's knowledge. The defense counsel is the one that went to the court and said, we want to make sure that we don't talk about polygraphs. The other issue,
Counsel, is this the distinction like Justice Johnson was referring to, the difference between the opinion about the polygraph examiner's opinion of the truthfulness of the individual versus what was said during the course of the polygraph?
yes. She did not express any opinions about truthfulness. She didn't express anything about results. And we cited one of the cases that said the mere mention of a polygraph at trial is not reversible error. But more significantly, even if that was error, that wasn't challenged. The only objection was going forward, let's not talk about polygraph. And to the degree that the prior testimony that was introducing her, any of that, to the degree it caused any prejudice at all, the law provides a remedy. The law says you ask the judge to tell the jury to disregard that. And if you think that wasn't going to work, if you did think that the jury couldn't disregard it, then you ask for a mistrial. Those didn't happen here. So the procedural prerequisites to preserve that complaint simply aren't in this record. The other thing that we talked about with regard to the reliability of polygraph is it doesn't matter. And it doesn't matter in the sense of we know, or it's always been the law, that law enforcement in interviewing someone doesn't have to be truthful. That one of the cases we cited from the U.S. Supreme Court was the traditional prisoner's dilemma, where you've got two defendants in different rooms. Police go back and forth and say, well, your buddy's already given you up, so you need to save yourself, even though neither one of them has said anything incriminating. U.S. Supreme Court said that's not a problem. What are the limits? Well, we know the limits. We know the limits are the law enforcement can't fabricate evidence. And we cited the case from 2010 where law enforcement agency created some documents and presented those documents as something that was in the case as truthful evidence. And court said, no, you're fabricating government record. You can't do that. That's the limit. That's not what happened here. He's not presenting anything that the polygraph examiner said was untruthful. It's just that it wasn't reliable. It doesn't matter. It doesn't matter because she doesn't even have to be truthful. To the degree that the court knows that it can't go outside the record. And with regard to all about 4 pages of the appellant's brief is outside the record, talking about the reliability of polygraph. The reason that those things have to be raised at trial so that the other side can respond is they would have had an opportunity to do that. Opposing counsel talked about the Reed technique. Had that been raised at trial, the state could have come in and presented all the evidence about the procedures that are used, the techniques that are used by law enforcement, and the absence of any case law that says, no, we can't do that. Because we know that the case law says, yeah, they can. As long as they don't fabricate some evidence, they can be misleading. But that's not what happened here.
Counsel, he, in the brief, takes issue with the way the, shall I say, the district attorney, the prosecutor, left out the word polygraph examination from the subsequent questioning of the witness and referred to it as an interview or investigation. Is there anything there that is preserved that we can reach in this appeal?
No, because that's what the defense counsel asked him to do. When they approached the bench, there was an agreement, and we got quoted that I asked him to present her as other than polygraph examiner. The court had said, well, let's call her, that I believe the prosecutor said, well, let's call her investigator. And the court turns to the defense counsel and says, you okay with that? Yep, I'm okay with that.
Okay, so any suggestion that the prosecutor engaged in what would be maybe labeled prosecutorial misconduct is not in front of us as far as your argument.
Now, there could be no misconduct where all of that was presented to the defense counsel and knew what it was. The only avenue that could have gotten to any misconduct is if it had been concealed. And this is the opposite. We're saying it was brought out. It shouldn't be, he's saying it should have been brought out, should not have been brought out to the jury. Well, if he wants to complain about that, the procedure is instruct the jury to disregard, move from this trial. So it's page 12 and 13 of our brief for that discussion about Mr. Burkeen was objecting to the discussion of polygraph tests. And the prosecutor is saying nothing objectionable from the testimony so far. She's made no mention of having administered the test, and they were just going to call it an interview. The court, Mr. Burkeen, is that your understanding? Defense counsel. Yes, sir, as long as it's clear to the jury that she's here to present interview results, which was also part of her job and not a polygraph. We can't complain on appeal about what he asked the court or agreed to have the court do in the trial.
So the interview results you're saying are admissible, but the opinions as to truthfulness are what is unreliable, and is the historical what we're generally familiar with is you can't introduce a polygraph.
Well, when you say interview results, the polygraph examiner did not testify to any results. What happened was that there were incriminating statements made toward the end of the polygraph. She says, hold on, let me get the local investigator in here. Local investigator comes in and just says, was there something you were going to tell me? No direct questioning. He repeats the same statement. But then they say, well, that's incriminating. I'm going to give you your Miranda warnings and then ask some more questions. So she did not testify to what was said, only that he said something incriminating. I got the officer to come in and listen.
At the point, and this is that moving line of where that custodial interrogation may begin, and I think the argument we're going to hear on rebuttal is that at the point that she had heard incriminating statements, if she's an investigator, she now has probable cause, and that at that point it shifted under United States Supreme Court precedent that he was no longer going to be able to leave, and therefore it was a custodial interrogation. And the statements that he made then to the investigator unmirandized when the detective came in the room would be inadmissible.
Well, and custodial and interrogation are two separate things. So when he makes the incriminating statements, he's not going to be free to leave. That's custodial. The officer comes in, he doesn't ask any directed questions. So what the trial court determined properly, we believe, is that even if he says, yes, you're in custody at this point, there wasn't an interrogation. He just comes in and says, was there something you were going to tell me?
Did he make any statement after he was Mirandized by the detective that was different from what he made before, that the statements before being Mirandized were more damaging, shall I say?
I don't think that I'm going to be able to answer that. My familiarity with the record doesn't go to the details of that statement.
But it was, that's not part of what's the objection here is in the briefing, is what you're telling.
Correct. Unless there are any other questions, I'll use the rest of my time, but we've covered the subject I need to cover.
Thank you, Council. Council, you have 5 minutes for rebuttal. You may proceed when ready.
Thank you. Our time with police conduct can cause a mere interview turn into an interrogation, at which point it's reasonable for any defendant or any suspect to believe that he is not really free to go. And I think we hit that here. One of the things that counsel had mentioned was the fact that she had that supposedly he made these while he was in the middle of the examination. However, she states, and I'm looking for it here. You haven't been run into it yet, but on the record, she states that, well, I was asking him all these things. You're not telling me the truth. All of these things. That was after the examination. So at that point, she is interrogated. And at that point, he certainly had no freedom to leave. Now, the interesting place that we find the defense counsel, because I would agree, he certainly should have completely rejected, did not. However, think of the subject matter. It's already, the horse is already out of the barn. Certainly the prosecution knows these are not things that you do. You don't bring up issues like polygraph. You don't present someone as being their sole job as being a polygraph expert. So that's first. But secondly, if I were to argue that, how would I argue? I would say, well, it's unreliable. But if I can't mention it, I can't even recover jury at this point. Because again, her sole job is to do polygraphs. What is the jury to think? Now, are we also to believe that these results were brought to the court, brought to the jury, were not evidence in the polygraph? So how are we parsing that? Are we saying that as long as we're getting through the yes or no questions that a polygraph might ask, you can't talk about? But if things pop up in the middle of the polygraph, you can. It's kind of hard to do. And it's hard to do because it's not an unbiased process. And there's where my problem with this issue is. It's not unbiased, but it is presented to suspects as being unbiased. We'll also, and obviously it's not the brief, and I apologize for this, but you will also note that it is also part of the process that they not have counsel. That counsel's not, even if he had counsel, he would not be allowed to be in there. So they can abuse it in any way they wish. That's improper. At some point, this kind of behavior needs to stop. I'll yield the rest.
As it relates to the voluntariness of the requirements from Miranda, to what extent do you attach the importance of I'm getting my stuff and I'm going to leave?
Oh, I think that's huge. I think that's huge because of the fact that you also, as part of the Reed method, part of what it is you do is, I'm here to help you. I'm here to help you, which is exactly what you said. I'm here to help you. And in fact, I believe her comment was, I'm here to help you only if you tell me the truth. Well, what are you going to do? What's the truth? Is it the truth, the actual factual truth, or is the truth what she wants to hear? You didn't start out right. There's where the problem exists. I agree very much that that is a big problem. Because if I tell somebody that I'm gonna pack my shit and leave, and I'm the only friend he's got at this moment in the world, that's a problem, because that makes the suspect kind of like that frog in a pot where the water's being heated up, and before he knows that he's already cooked.
Thank you, counsel. This case is submitted and y'all are excused. At this point, we are going to shift into a Q&A session. As soon as council, we're going to give them a minute or two to vacate the tables so that they can relax now that their case has been submitted. And we'll put the pressure on y'all to ask interesting and intelligent questions. So, Lindsay, did you have some already written? Where'd you go? No, Lindsay has no questions. She's collecting them. Okay.
Anybody need a card?
There are some folks among you that have some cards. Now, all your law enforcement cadets, don't leave. Yeah, I mean, y'all are the ones that should have the best questions. So, no, if y'all need to go, y'all go ahead, do what you need to do. Any questions from the audience? Be careful how you yawn there. You may wind up asking a question. See, you kind of look like you have your hand up to ask a question. Yeah, you. It's like an auction. You have to be careful. So seriously, if anyone has a question, you can either stand and speak loudly from where you are or come up to the microphone. There it is.
Hello, my name is Peter Clayton, I'm a teacher of government here at MCC. Thank you for coming to do this for our students. It's I who pointed out that September 17th is Constitution Day, and this was a fine way to celebrate our Constitution. For the students, could you kind of explain the process after hearing oral argument, how things unfold in conference and the sorts of things that you all do kind of behind the scenes? You did that for our students, that'd be great.
Matt, go ahead.
Well, normally after oral arguments, we have a post-submission conference, because the cases get submitted at argument. And that's when we, all three of the judges are present along with staff attorneys from the court. And we discuss the issues and try to boil them down to some extent so we can figure out how we want to move forward with them, decide what areas may need more research before we make a final decision. And then all cases are assigned to a particular chamber at the court. And so that chamber actually then after the post-submission conference takes it and runs with it basically, and then they prepare a draft opinion that is circulated to all of the judges on the panel. And so, sometimes after oral argument, it can take a while for a chamber to work up an opinion on a case, particularly a complex one or a novel area of law. So that's pretty much the way it works. I'll have anything to add?
Anything on that? Yeah. Where do you go? Yes, please.
Many years ago, I got falsely accused of something, and I had offered to do a polygraph, and they told me that it wasn't admissible in court. So I'm curious as to why, in this particular case, it's admissible. When I hear it on TV, and the police told me the same thing during my case. So I'm just curious about why there's so many differences. How come it being admissible here, but not in other circumstances?
Excellent question. You want to take it first?
Well, in reality, the fact that the polygraph test was given and the results of the test were not admitted in court. What happened was the lady who actually gave the test simply came up and testified that these were the answers that he gave to my questions, as I understand the record as we have it. So there was no polygraph results admitted in the case. It was just the fact that she was a polygraph examiner. And she testified as to what the defendant told her in response to her questions and any statements that he gave on his own.
But because the law says that polygraphs are inherently unreliable, the opinions of the person who conducts the polygraph about whether the person is being truthful or not are not admissible in court. Now, if you sit down with someone who's accused of something and then at the end of the polygraph, they say, oh, well, I might as well be honest. I did the whole thing. I'm guilty and all that kind of stuff. That's just a direct admission. Those have always been admissible. And so a polygraph is sort of an interview. If you've ever had one done, observed one being done. And admissions that come up during the polygraph, the question and answer session are traditionally admitted. Now, the polygrapher's opinion about whether they were being honest or truthful, that doesn't get to come into evidence. That's the difference.
They've covered the difference between the polygraph examiner's opinions versus the statements of the defendant. I'd like to relate a personal experience because Matt said, if you've never been hooked up to one of these machines, it's sort of interesting to see how it works. When I was in college, I got hooked up to one during a psychology class. I was the only senior in the class. And they hooked me up to one of these, and it was primarily a freshman level class. And so the instructor then started down this scenario like a polygraph examiner would do, asking me the rote questions of, what's your name? Where do you live? And then he just said, now let's turn to some more personal questions. And man, the thing just went nuts. He didn't even have to ask me the question. My physiological response to even being subject to just caused it to go off the charts. And I didn't say anything. I mean, it was nothing. And so the point of that is, and I think counsel would agree, it takes someone that is skilled at this process to even begin to interpret the results. And because it is so inherently unreliable, that's the reason that historically the polygraph examiner's opinion as to truthfulness is not admissible. And that's the distinction we're starting to deal with here in this case. And we can't talk about the particulars of the case, of course, and how that teases out into the law. But as I understand, based upon your question, what you were told is correct, is that the results of the polygraph exam are not admissible. And that is the reason that many law enforcement agencies don't do it, because it does take time, and it is money. Time is money. So any other questions? Yes, sir.
Hello, my name is Michael Matthews. I just had a general question as someone who's not well versed in law, and maybe y'all just explained it, but maybe I cannot understand it. So once these cases are brought up to y'all to appeal, is there an instance where it does not go any further past y'all, or does it always go further past y'all to more judges?
Most of the cases that we hear end at our court. And the reason is because we are required by law to take every case that comes in our front door. We have a two-step system in Texas, only one or two states, Texas and Oklahoma, that has two high courts. We have the Texas Supreme Court that handles civil cases. We have the Texas Court of Criminal Appeals that handles criminal cases. A person who has usually lost in our court, who wants to take their case up, can ask that it be taken up. but there's no guarantee that it will be taken up. Those two courts decide which cases they want to accept to hear. And so for the most part, what's the percentage, Chief?
I think it's about 95% stop with us.
Okay,
And the next layer is, they call it discretionary review. And if you file, it's very detailed procedure set out in the rules, and you file a petition, and you, as Steve said, you basically ask that next higher court, will you hear my case? And explain why it's important to the jurisprudence of Texas, or a particular legal issue that they should hear your case to set statewide precedent. The other factor that plays into that is that we're 18 counties in central Texas. When we write an opinion, the judge is deciding courts at the trial level, or cases at the trial level, they have to use that precedent. It's binding on those 18 counties. If you, and in fact, as an example, if you go to Grimes County, which is not in our district, there are judges in Walker County that also sit in Grimes County. If the case is from Walker County, they have to abide by our precedent that we set. If they go to a case in Grimes County, they have to go by the precedent of the 1st or the 14th Court of Appeals, where the appeals from Grimes County go. If there's a split between the intermediate courts of appeals, you can imagine that that is an issue that the high court is likely to want to resolve. Now, sometimes they let it cook a little bit down here until it gets well developed one way or the other. And then they'll take it and decide the issue. But you have a follow-up question.
I did, so obviously y'all have been justices for at least 3 years together. I believe you've been here since 2. There we go. Do y'all generally find yourselves, your opinion or stance on cases beginning to merge, or do y'all still feel like y'all have very separate standings as far as?
That's a trick question, isn't it?
I'm just curious.
I'll let Matt answer that.
We have varying opinions. Some of the decisions we make are close calls. And so it's not uncommon. All of us have unique backgrounds, and law is law, but still we deal with some issues that aren't totally clear cut, and we have to make the best call we think we can at the time. So, but we do our ideas about the way a case should go does vary.
and I will say that just like the US Supreme Court, which you would never believe, the vast majority of our opinions are 3-0 opinions.
And that's exactly what I was going to point out, is that while it is the differences that catch attention, the truth of the matter is that we agree far more than we disagree. But yes, there are differences of opinions. Excellent question. Anybody else? Please. It's what it's up. That's the reason we come to the college campus is we want to be part of the process. Yes, ma'am.
Is it common that you can, this is like all things, you can see that the defendant that's appealing is like at fault, or we know they're guilty, that they did something wrong? Is it common that you guys see them give that appeal, or they still, I guess you could say, could win because their attorney has more support, they have more facts, so it seems more persuasive versus we see the person, like in the first case, like we know that he was wrong, the defendant was wrong when he did that, whatever his own opinions, but it seems that that attorney has, we have more support in what he said, like, is that very common that y'all see that, like, when you're judging, like, it's like.
I'm gonna let these two go first because they were both trial court judges before they became appellate court judges. And I think that sort of plays into the answer.
I'll let the senior justice go first.
Y'all never been so deferential. Well, you know.
And let me expand on your question and ask you to answer it both as a trial court judge, when you are the finder of fact versus the role of the appellate court.
What we deal with in the appellate court is whatever the record is from the trial court. We don't get to add new facts to the record at all. So really, it has to be developed in the trial court, okay? And so let's say that there's evidence or facts about a suppression issue, whether we're going to suppress evidence or not, or whether it's facts dealing with the commission of the offense itself. And people are always allowed to put on a defense if they have one, or if they have anything that might amount to that. I mean, a lot of people don't put on a defense. They assert their Fifth Amendment right to remain silent. You've got to remember that they don't ever have to come to court to prove their innocence. The state has to come to court to prove they're guilty beyond a reasonable doubt. And that's why people take the Fifth and don't testify. And because they don't think the state's proven their case beyond a reasonable doubt. Also, juries don't find people innocent. They find guilty or not guilty, okay? And not guilty doesn't mean that they didn't do anything wrong. It means the state didn't prove their case beyond a reasonable doubt. The burden on the state to always prove it. It's not a balancing of who do we believe here, generally. It happens sometimes. Sometimes it comes down to that. But it's really whether the case is proven to the appropriate legal standard. And like I said, it's all developed in the trial court, and you'd have to really go with what the record is there.
And that sort of adds the question of, did I ever disagree with the jury? I will tell you that in all, I just happen to be the longest serving trial judge here, almost 23 years before I came up here. I can really only recall of 3 cases where I thought the jury got it wrong. And you can figure out how many thousands of cases I heard in 23 years. And so we're using the same system, we're using the same rules that Matt talks about. In civil cases, it's a preponderance of the evidence. In other words, more likely than not that something happened or did not happen, and beyond a reasonable doubt. And I love what Matt said about this, because it's very, very important. Our system is developed on the fact that we have a set of rules. And I personally am not offended that if the state is going to take away your liberty, perhaps take away your life, that they got to do it by the rules. And if they don't do it by the rules, they don't get to do it. And it's not, you know, a friend of mine who's used to be the public information officer of cases in Kansas. He would read people when they said, "Oh, he got off on a technicality." Well, he would politely write the guy who says, "Oh, I believe you're talking about technicality number 4, which happened to be the 4th Amendment to the U.S. Texas Constitution, which says you can't use illegally obtained evidence." You know, so it's not technicalities. They're rights that we have inherent in our Constitution.
Well, I was a trial judge for very brief period of time. It was in a municipal judge court, so it was Class C offenses. Most of my career has been as an appellate court judge, working on 25 years. One of the most frequently asked questions is, especially when I first started, is it difficult to address a case on a reversal when you know that the person is guilty. And then the other side, or the other way of looking at that from the appellate level, is when you disagree with what the trial court did, neither of those questions is my job. I'm not reviewing or determining whether or not I agree with what the trial court did. My job is to determine whether or not the trial court erred, and did that error, if I find it, affect the judging. And to answer the first question, I found it was much easier than I thought it would be to ignore what is the perception of guilt or not of the defendant, and say, what is the rule? What is the result of having erred in the interpretation of that rule? And that to me became much easier as I went along, but it was never difficult, because we are a system of laws. If we do not follow the rule of law, then it's just mob rule. And that's the whole point of today and Constitution Day, and the fact that we have a Constitution, and it's the same rule that applies to you, as applies to you, as applies to Clint. You know, it's the same rule applies to all of us. And then what's happened is there's been a determination, and somebody's been found guilty or not in a criminal context. Now, come back this afternoon for the 130 docket. It's a civil case, and it is a little bit different. Well, it's a lot different than a criminal case. And I refer to it as an exit ramp. The city in that case took an early exit ramp, a summary proceeding to determine that they weren't liable for a traffic wreck, intersection collision. And so where Matt was talking about finding facts, in that case, the issue is whether or not there are any facts that are different, that they disagree on. And I'll stop talking about that case, because that's pretty much the limit of what I can say about it. But the point is, to your question, it's a little different in civil and criminal, but it is generally, and I think I speak for all of it is generally not difficult to ignore the guilt or innocence and apply the rule of law. And that's why it's really important that y'all understand that distinction and what it means, because it really is what separates us from mob rule. I mean, that is what has to happen. So, excellent question.
And from the countries where you're presumed guilty and you have to prove your innocence.
I just have one more. So today y'all heard 3 cases, as you stated, you heard thousands of cases. That is within different realms of court. How many cases, or what percentage of cases do y'all think they y'all actually end up turning over every year due to court year? As far as how often is the trial courts erring to the point where it comes to an overturned case?
Do they have the numbers?
I was gonna make a funny out of it, but it's a serious question. These 2 guys were very active trial court judges, and they made lots and lots and lots of errors. But very, very, very few of them actually affect the result, the outcome of the case. They don't affect the judgment. And that's what you've got to have a successful appeal, is you've got to have an error that we can address, that affected the result in the case. And I actually don't know the percentages on reversal, but it is very low. I mean, I would be surprised if we reverse more than 15% of the cases that come to us. And the other piece of that math is, post-COVID, we're getting about 400 cases a year. I'm sorry, that was pre-COVID. Post-COVID, it's been about 300 a year. So wait, one more correction. It was 500 before. We would transfer out about 100, so we would have about 400 to decide here in Waco. And now it's about 400 filed that we have to hear. But with the fewer cases being filed statewide, we're down to about 300 that we have to decide. So, but very, I'm sorry, I don't have that number, but we do not reverse many cases. So.
If I recall 5 or 6 errors I made in those 20.
But it really is, I mean, go ahead and tell them what you say is the difference between being a trial judge and appellate judge. How fast, yeah.
Somebody asked me one day, what's the difference between a trial judge and an appellate judge? I said, well, an appellate judge has 6 months and 2 other people to help decide what I have to do myself in 5 seconds.
And that really is a good characterization because, you know, you're sitting up there on the bench and this, an issue comes up and a lawyer pops up and makes an objection that's hearsay. And, you know, the trial judge has got to decide like that, whether or not it's going to be admitted or not. And then assuming it comes in, then, you know, it gets found guilty or it results in entry of a $10 million verdict. It comes up on appeal. And then we go through that question of whether or not that was hearsay and whether or not it should have come in or not, and then whether or not it affects the result. You know, it may be something that is completely unrelated to the finding of liability or damages, and so it just doesn't matter. So.
Yeah, state trial judges don't have a large staff that work. I mean, as a district judge, I did not have a staff attorney or a briefing clerk, anything like that. You really rely on the lawyers on each side of the case to present to brief the law and to present it to you. And then you got to make a call based on that. But, you know, it's not like now where at the Court of Appeals, we've all got 2 staff attorneys. I mean, career attorneys who help us research and write and work through the legal issues. And we've got time. But you're in the trial court, you've got a jury in the jury box, and they're all waiting. They don't want to be there any longer than they have to, and you want to move the case. And so Judge Smith's right. Have to make some of these decisions in about 5 seconds. Then you rule and run is what trial judges do.
Last question. Anybody? Yes, ma'am. Oh, hang on. Got a question back here.
I'm just curious how all of you approach interpreting the Texas Constitution, and if that's, I guess, your job as the court. Are you more of like an originalist or a textualist?
Words mean things. But really, we very rarely get into Texas constitutional questions. At least I haven't. You may have in your time here, but we very rarely get that far down the road.
The bulk of you know, textual interpretation that we do is interpreting statutes. And I agree with Judge Smith. I don't know that I've actually seen a Texas constitutional issue in the almost 3 years that I've been at the court now. But statutes, I agree with Judge Smith, words mean something. The legislature enacts them for a reason. And we need to stay, you know, legislature makes the laws, we don't. Okay, that's one thing that's one thing appellate courts shouldn't do. We take the law as the legislature enacts it, And then we have to just apply the facts to the law to get the right result.
Direct answer to your question, would probably be classified as a strict constructionist. It is, the interpretation of statutes and constitutions, it's more difficult at the state level because we have very little developed history, like for our Texas Constitution, and then the Texas Constitution has changed so much over its life. The U.S. Constitution with the Federalist Papers, there's a rich history of the kind of historical context in which that document was written. You know, especially given that we're here celebrating Constitution Day, that document is well developed. I mean, originally 4 pages, relatively few amendments. We've had years in Texas where we've had more amendments in a year than the United States Constitution has had in its entire existence. And there is a lot of literature and discussion now about this whole concept. And it is not, that's much more difficult than in answering your question of how do you approach this? I mean, when you've got a question where I'll use the property interest of an individual is involved. And we had a case, it was City of Glen Heights versus Sheffield a number of years ago. And the question was whether or not the Texas Constitution provided more protection for a property owner from having his property taken by the government without adequate compensation than the Fifth Amendment to the United States Constitution and the way that the due process clause has been applied to the states under the 14th Amendment. And so there was a question of whether or not the Texas Constitution provided more than the federal Constitution. And our court held that it did, that the Texas Constitution provided more protection for a landowner than the United States Constitution. And then I was told about 2 years later by the 9 justices on the Texas Supreme Court that I had misconstrued the Texas Constitution. And so, you know, we have to do it in light of our high court, the Texas High Court, as well as the United States Supreme Court, depending on which one we're interpreting, the way they have interpreted. We are obligated to follow their interpretation. We don't get to do it as a matter of first instance. And so with that, I think we'll have to leave it there. And just really appreciate all y'all coming out today. I know that you had to, you know, we compelled 4 people so far to be here today. Well, maybe 5. And but for y'all that don't know, and there's no reason that any of you would or should, today is Beverly's first time as the court clerk. Recently retired, and Beverly was appointed. And so today is her first call of court. And so I think y'all should give it a round. And with that, we're going to adjourn and stand in recess until 1:30 when the afternoon docket is called. Thank y'all very much.